go on the record matter of the City of Riverview versus Chad Johnson, 24470. And appearance for the people, please.
Michael Hurley on behalf of people of the City of Riverview, Your Honor.
All right, your P number, counsel, please.
37519.
All right. And Mr. Johnson, your appearance, please.
Please, the court. My name is Kim Johnson. I represent defendant P37520.
Okay. And Mr. Johnson, Mr. Chad Johnson, your name, please.
Chad Harold Johnson.
I need you to speak up louder.
Chad Harold Johnson.
All right, thank you. Okay, so Mr. Hurley, you're appearing on behalf of the City of Riverview because there's a conflict with Mr. Carmen representing the City of Riverview in this matter, correct?
Yes, that's my understanding. Mr. Carmen previously represented young Mr. Johnson there in a matter in 33rd.
And so we're going to proceed with the arraignment today, and we're going to adjourn the pretrial, correct?
Yes, Your Honor.
All right, so Mr. Hurley, procedurally, I'll need you to submit your appearance on that, I think, for the limited purpose of this matter.
An appearance and a plea sheet?
Yes, and then we will adjourn the pretrial to June 10th. What time can you appear, counsel?
I can appear first thing.
I'm sorry, Mr. Hurley.
Anytime that's convenient for Mr. Kim Johnson. In the court, of course.
Okay. All right, and I'm sorry, Mr. Johnson, you said anytime works for you?
Yes, Your Honor.
Okay, are you in another court on Mondays, Mr. Hurley?
I am not, Your Honor.
Okay, so would you rather be here first thing, middle, or later morning?
Early and get it over with.
Okay, so let's do 8:30. That way that'll be before Mr. Carmen gets going with that part of the docket. All right.
Appreciate you, Judge.
Okay, all right, so we'll do June 10th at 8:30. All right, thank you, Mr. Hurley.
Okay,
All right,
thank
and
you,
then
Judge.
as to the
Anything else for me?
Nope, we're going to do the arraignment.
Okay, I'll leave. Thank you.
Thank you. All right, and Mr. Johnson, as to the arraignment.
I waive the reading stand, Your Honor.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And I'll note the pretrial was held with Mr. Hurley. Okay, and as to, Counsel, you did say waive the formal reading, correct?
Yes,
That's what I thought.
that's correct.
As to bond.
Your Honor, we've asked the court to consider personal bond in this matter. I think my client, who's lifelong resident of this area, will show off for his next court date. The candidate for personal bond.
Okay, and so I'm just going to refer to you as Chad, okay, just because I don't want the record to be confused between your dad, Mr. Johnson, and you, Mr. Johnson. And so, Chad, where do you work?
I worked at the
And how long have you worked there?
on and off for about 10 years.
On and off for 10 years. Okay, so how long has it been that you've been back on working there?
Just about a week.
And when you don't work for your dad, where do you work?
I previously held jobs in gyms. The last one was Plea Fitness. Other than that, I've had trouble with transportation and toilets.
Okay, so you don't have a valid license?
No,
You have a valid license, but no means of transportation.
actually, an expired license.
If you were to test right now, sir, what would be detected in your system? When's the last time you did any huffing?
That would be, it was after the state.
Okay,
Very sure.
would it be yesterday?
No.
Would it be last week?
The incident was in March, I believe.
Yes.
Excellent.
Can you speak up, sir?
Beginning on the end of March, Your Honor.
Can you pick that up or no?
No. It would have been end of March, Your Honor.
Are you out on bond in any other jurisdiction?
No, Your
Other than, this matter that had to be rescheduled, due to hospitalization, have you ever failed to appear in court for any reason?
No, Your
All right, and are you currently on probation or parole anywhere, sir?
I'm on probation in 33rd.
Okay. And counsel, I see that there's a no assault of threatening, coercive, intimidating contact order that you're named in, as far as the protected person, you and 2 other individuals. Do you think there's any conflict with you representing Chad with that issue also?
No, Judge.
And Chad, you are asking your dad to represent you. Here's what I'm going to do. I'm going to order a $7,500 personal bond. You're not to possess or consume any alcohol or drugs that are not prescribed. Would there be anything detected in your system, sir?
No, Your Honor.
All right. All right, we'll see you back next week at 8:30 a.m.
Thank you,
All
Judge.
right, thank you. All right, have a good day.
Yep. Okay. Go!
Hand me my screen box. Now go. Freak.
This is the matter of the City of Riverview versus Alexandria, step 24499.
Morning, Your Honor. Attorney David Leckman, P number 67994, on behalf of Alexandria Step, who stands to my right. Mr. Director, please.
Alexandria stuff.
Okay, good morning. Okay, and today is the date scheduled for the arraignment pretrial in this matter, and then ask the arraignment counsel.
Thank you, Your Honor. We've waived formal reading information, ask the court to stand in a step mute and plead not guilty on her behalf.
The court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment as to the pretrial.
Thank you, Your Honor. I had an opportunity to speak with the city prosecutor in this matter, and in return for a proper no contest plea to the amended charge of operating visibly impaired, the people of the charge of operating while intoxicated due to high VAC. Step has signed an advice of rights, it's in the file, and also putting these rights to her. She understands she has an absolute right to go to trial, whether by judge or jury. See, here a question of the evidence the city of Riverview has against her in open court. Call witnesses to speak on her behalf. The witness for herself or remain silent, and that silence could not be used against her by the prosecutor. She understands that by accepting this guilt, there's no contest plea, she'd be waiving those rights to trial. She would not be able to call witnesses to speak on her behalf, cross-examine the city of Riverview in open court, to be a witness for herself or remain silent. She would not be presumed to be no contest. Correct.
Yes.
Is that your phone, sir? It needs to be off, please. Thank you.
The
And counsel, what would be the basis for the no contest plea?
lack of recall.
All right, please raise your right hand. You solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth.
I do.
All right. And you heard the plea that your attorney placed on the record, correct?
Yes.
As to the amended charge of operating while visibly impaired by alcohol, how do you plead?
No contest.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And in fact, your attorney expressed that on the record and all of those rights that you understand that you're giving up. Do you understand that?
Yes.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
I'm sorry?
Yes.
And knowing all that, you want to continue with your plea.
Yes.
You also understand what a no contest plea would entail.
Yes.
Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
No.
And any immigration issues?
No, Your Honor.
Any objection to the court reviewing the police report for the factual basis?
No, Your Honor.
All right, just one moment. All right, the court has reviewed the report, and the court, stipulating to the police report counsel, I presume, I'm sorry, in having the court review the police report for the factual basis, Are you stipulating to the blood test results that's, as a result of the police report, counsel?
We are, Your Honor.
All right, the court does, find the plea is knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement. You'll go over to probation, you'll get your pre-sentence interview date and your sentencing date. As to bond, counsel.
Thank you, Your Honor. We would ask for a personal bond, Your Honor. This is Ms. Stepp's first such charge. She retained me shortly after the arrest date. She is not a flight risk. She will continue to show up as ordered by the court, and she is not a danger to the public at this time.
And where is it you work?
I'm currently unemployed.
And when's the last time you were employed?
I was employed like about a month ago. I just quit my job.
Okay, and did you quit it because you have another one lined up?
Yeah, I'm going to get another one. I've been applying.
Okay, so that was, so then, no, you
Well, I
haven't.
didn't have one, no.
Right, okay, so where were you working?
I worked at Taco Bell. I was a manager for like 2 years.
Okay, and so you quit
Yes.
without having another job and source of income lined up?
I was applying on Indeed, but I had not gotten a call back from any place that I had.
Is there a reason why you had to quit right then as opposed to waiting until you had another job?
I just couldn't deal with the circumstances that were going on at my work, and it was just a lot, and I just didn't feel like I was getting that recognition there. It was just too much. I really would like to do something else in my life, so.
So how are you supporting yourself right now?
I have another source of income.
Which is?
It's like an internet thing.
Okay. Which could be a lot of,
Content, provider. Your Honor.
I'm sorry, what?
She's a content provider on the internet. She
Okay.
videos.
Okay. Okay. And have you ever failed to appear in court, ma'am?
No,
Are you currently on probation or parole anywhere?
no,
Are you on bond in any other jurisdiction?
No.
And if you were to test today, what's in your system?
nothing.
When's the last time you consumed any alcohol?
A month ago.
The courts, did you post a bond, ma'am, or was it a cash bond or was it a personal bond?
It was
I
personal.
believe yes. I believe it was a personal bond. They released her after.
All right, the court's going to order a $7,500 personal bond. You're not to possess or consume any alcohol or drugs that are not prescribed. And based upon the level of intoxication that existed, the court's going to order you to participate in random testing
As a condition of bond, Your
as
Honor.
a condition of bond, yes. Yes, as opposed to an alcohol tether, the court's ordering the random testing. So you're not to possess or consume any alcohol or drugs that are not prescribed. Do you have any prescription medication?
I'm prescribed Ritalin, but that's it.
Okay, so you just have to make sure you're supplying that to probation. You're not on probation, but as a condition of bond, that way, if you're testing positive for the ingredients of Ritalin, you have a valid prescription. Okay, so you can please have a seat over probation. Somebody will be with you shortly.
Thank you, Your Honor.
Thank you. Have a good day. All right, let's go off the record. Ms. Buckoff? Okay, can we have
Thank
Mr. Williams come in, please? Can we have Mr. Williams come in, Terry? Williams, Mr. Williams? Thank you. All right. All right, we're recalling the matter of the city of Riverview versus the Alexandria, step 24499.
Morning, Your Honor. For the record again, Attorney David Lechner on behalf of Alexandria Step, who stands to my right.
Alexandria stuff.
Okay,
Your Honor, we would like to correct the record. When the court asked if Steph was working, she is an independent contractor. She's a dancer. She did quit her job previously. She is looking for new full-time. She is technically working.
okay. So Taco Bell was or was not an employment?
It was.
Okay.
previously. Yeah, she did that. That's correct. She currently is employed as an independent contractor.
Okay, and so the internet
That she has an internet presence as well, but she is dancing.
Got it. Okay, all right, thank you very much. I appreciate that correction. All right, thank you. Have a good day. Come forward, we're going on the record in the matter of Edward Williams versus Mark Jones, all other occupants, 2400728. And Mr. Williams, your name for the record, please.
Edward Williams. Morning, Your Honor.
Good morning. And Mr. Jones, your name for the record, please.
Mark Jones.
Okay, and so Mr. Williams is in person. He was having some technical issues. And so Mr. Jones is still on Zoom. And so Mr. Williams, the two of you were able to speak in a breakout room on Zoom. And has there been any resolution?
No, there isn't. The only resolution I suggested to him to leave it to the court stands.
Okay, and so then are we proceeding with the hearing?
That's right.
Okay, Mr. Williams and Mr. Jones, I'm gonna have you both please raise your right hands. Do you solemnly swear or affirm the testimony about to give this matter the truth, the whole truth, nothing but the truth, Mr. Williams?
Yes, Your Honor.
Mr. Jones?
Yes.
Okay, and so today is the date scheduled for this matter, and Mr. Williams, this is regarding unpaid rent, is that correct?
No.
No, let me
Just possession.
just possession, okay. And so how long has Mr. Jones been residing at the property?
Right, Your Honor. 8 years, 7. You would probably know that.
Well, sir, this is your action, so you need to have that information.
I didn't bring the lease with.
It's probably about 5 years. Let's say now, at least.
Okay, and so, you provided Mr. Jones with, notice that you would like him to relocate, correct?
Yes, Your Honor.
Okay, and so, Mr. Jones,
Yes.
are you objecting to that?
Well, eviction's kind of. I explained to him that we're looking for a place. My wife just had a baby, and I asked him about the money situation. He says it's not about the money, but when I paid him last time through the court, it didn't state exactly what that was. So, I don't know exactly why he wants this gone, but the timeline was we're looking for a place.
What do you mean? You gave him money? Hold on, sir.
Yes.
You stated that you gave him money. Was that for rent?
Yeah.
When did you pay him money for rent?
The
I'm sorry,
last
you're breaking up.
court date, I gave him $2,000. Beginning of March and April, and it wasn't.
Okay, and so how,
And we were paid in full, and then we were paid in full, and then the next day I get eviction notice. Not stating, I didn't get any statement where the money was allocated, or if I still, if he's after he evicts me, I collect any money, or what's the reason like so quick and not give me any time, because I'm abiding. If he wants me out, that's okay with me, but I have to have a little time to find a place. We thought we had one, it kind of fell through, went to somebody else. So
okay, well, sir, the law states you get 10 days.
10 days after even if I'm paid and everything.
So you paid, the money you paid was for your rent through what month?
We were all paid up until the eviction notice came on the door. I also got a phone call that maybe they
What month was that, sir?
May. Oh, this one right here. That was May 3rd. He put the eviction notice on my door, so I do believe we were paid through May.
Okay.
Wait, you believe you should be evicted? Yeah, the eviction notice was till April 3rd. By him. No, nothing by you, just by him.
Okay, yes, Mr. Williams?
The money that he paid in full was from the court case from an eviction, non-payment.
I'm sorry, from what?
He paid from a non-payment court case. He
Okay,
paid in full what we decided on court that day.
okay, and is there a written lease?
Yes.
It's month to month now. We didn't get a new lease.
Okay, so now it's been month to month.
Yes.
And so on April 3rd, you provided Mr. Jones with a notice to quit, a 30-day notice to quit?
Yes, he was paid through till March.
Okay, so April 3rd, you provided Mr. Jones with a notice to quit.
For sure.
Okay. And then you filed this action in May.
Yes.
Okay, sir, you've had 2 months. You've had 2 months to find a place to live. So you're saying you need more time. What does that look like to you?
2 months is fine. I appreciate
No,
that.
sir. No, sir. No, that's not what I said.
Oh, I'm sorry.
I said you've had 2 months since you were informed that Mr. Williams wanted you to relocate. You've had 2 months. Today has been 2 months. So how long is it you're stating that you still need to find a place to move?
I don't, I could possibly do it in a month. You know, would give me plenty of time.
Well, you've had 2 months. So then why are you not out? Why have you not relocated?
April. Like I said, we had a place that we were moving into, but it fell through. It went to somebody else. So we've been looking, and we're signing up for a few others that are you know, available immediately. So, you know,
So, sir,
yes,
why should Mr. Williams have to be responsible for that?
I guess he should.
Right. Mr. Williams, are you in agreement with giving Mr. Jones any additional time?
I'm doing 15 days.
Okay, Mr. Williams is giving you 15 days, sir. So instead of June 13th, you have until June 18th.
Okay, appreciate that. Thank you.
Okay, so the court will note after hearing that does find plaintiff has a right to recover possession of the property, about that there's not an amount due at this time. If defendant does not move on or before June 18th, plaintiff may apply for an order evicting the defendants. Additional money may be owed if damage to property occurs or rent continues to accrue. No money judgment entered at this time. And the court has signed the judgment, and so Mr. Williams, you can receive a copy of this in just a few moments, okay? All right, and then you'll receive a copy of the mail, sir, unless you want to come and pick up a copy.
Okay,
All right, thank you.
thank you.
City of Riverview versus Jonathan Reeves. 232217. Oh, your name, please.
Well, Jonathan Reeves.
All right, and sir, today's the date scheduled for the formal hearing on your, the second part of your case, which is disobey traffic control device. And as to that matter, sir, you had an opportunity to speak to the prosecuting attorney, correct?
Yes.
And it appears as though you're pleading responsible to the traffic device, is that correct?
Correct.
All right, please raise your right hand. Do you solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, and as to the charge of disobey traffic control device, how do you plead?
Responsible?
You've gone over, you understand you have the right to have a contested hearing in this matter. By entering into a plea, you'll not have that hearing.
I understand.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
I believe it is.
Okay. And knowing all that, do you want to continue with your plea?
Yes, ma'am.
Anybody promise or anything, threaten you, or coerce you in any way for you to enter into a plea?
Your prosecutor was very inappropriate and was threatening to raise the charges if I didn't take this plea. So, yeah.
Okay, well, let me just clarify something, sir. He's not the court's prosecutor. The court doesn't hire prosecutors.
I
The city-
apologize then.
No, I just want to clarify for you, sir, that the city of Riverview contracts with the prosecutor, with the attorney to do the prosecutions for the city.
Okay,
The court does not do the hiring or anything of that nature, or the supervising or anything of that with the prosecuting attorney. So if there's an issue, sir, you can certainly contact the city of Riverview, regarding those concerns. Okay, because the court doesn't, we're a separate branch of government.
Okay, I was unaware of that.
No, I understand. A lot of people,
Assume that.
yes, I also assume we hire the police department, so, right, okay. And so, so do you want to continue with the plea, sir?
I did. I just wanted it stated that this is my 12th time coming to court, having to call off, having to come here for their incompetence of not being able to format a video and
Who's there incompetent?
prosecution. And I felt like that was nothing but a way to threaten me and to try to scare me to take a plea. And I'm doing this just to solve this because this has been going on since September and I'm ready for it to be done.
Okay. All right. The court,
I
that's
really
fine.
think it should have been dismissed or dropped to impeding, but I'll deal with what I have to take. Sorry to interrupt you.
No, you're okay. Well, I can't just reduce it to an impeding
I understand.
traffic, and I can't just dismiss it.
I just wanted to say what I wanted to say.
Okay. Okay, and so, let's find the plea is knowing and voluntary, and the court will accept your plea. As to the traffic control device civil infraction, it's $150. You have that to pay today.
Yes, sir.
Okay. So you can just have a seat in the lobby outside, and somebody will be with you shortly, okay, sir? Thank you. Have a good day. Let's go off the record.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're gonna start bringing people in person. People gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.